Well, welcome, and thank you for joining us for this afternoon's UVault Law in Focus webinar, Attacks on Abortion Access, the Road Ahead for Reproductive Justice. I am Professor Margaret Johnson, Associate Dean for Experiential Learning here at UVault Law, and I also serve as co-director of the Center on Applied Feminism and director of the Bronfein Family Law Clinic. My research is in the area of reproductive and gender justice. On December 1st, the Supreme Court will hear an appeal of the 2018 Mississippi law banning abortion after 15 weeks of pregnancy, which I'm going to put in quotation marks because that's measured from the last menstrual period and not actually conception. Mississippi AG's brief to the Supreme Court in Dobbs versus Jackson Women's Health Organization specifically calls for the overturning of Roe versus Wade, the 1973 Supreme Court case announcing women's constitutional privacy interest in an abortion. We also have a new law in the books in Texas, SB 8, that bans abortions after detection of cardiac activity, which can be 6 weeks since the last menstrual period or even earlier. SB 8 also empowers citizens to act as bounty hunters of anyone who aids or assists someone in obtaining an abortion. Joining us today to try to make sense of all of this are our three terrific panelists. Jill Morrison is a professor at Georgetown Law Center, where she is executive director of the Women's Law and Public Policy Fellowship Program and the Leadership and Advocacy for Women program. She also spent 13 years at the National Women's Law Center, where she worked to protect and advance access to comprehensive reproductive health services and to protect the rights of vulnerable, pregnant, and parenting women. Jen Mahan is a University of Baltimore law alum, currently working as a fellowship attorney with the organization Regulatory Assistance for Abortion Providers, a division of resources for abortion delivery. She also serves as Director of Development and Community Engagement for the Birth Rights Bar Association. Before taking her current job, Jen completed an If, When, How state policy fellowship with SPARC, Reproductive Justice Now in Atlanta. Michelle Gilman is Venable Professor of Law and Associate Dean of Faculty Research and Development at University of Baltimore Law. In addition, she's a co-director of the Center on Applied Feminism and director of the Saul Ewing Civil Advocacy Clinic. She's an expert on privacy law, feminist legal theory, and law and poverty. We very much want to entertain your questions and comments along the way, so please use the Q&A function of Zoom to share your thoughts. We will get to as many as we can. But before we get started, let me just set the table by providing a brief note about two leading constitutional Supreme Court cases and one federal abortion law that are relevant to our discussion. First, Roe versus Wade, decided in 1973 by the Supreme Court. This case overturned Texas criminal statutes prohibiting abortion, except in cases where the life of the mother was endangered. Writing for the majority, Supreme Court Justice Blackmun ruled that the right to personal privacy is fundamental in the concept of ordered liberty, and regulation of such rights would only be permitted under the substantive due process clause if there were a compelling state interest and the legislation was narrowly tailored to those interests. The court established a trimester framework as follows, and this framework was trying to balance competing interests of the state and women. First, prior to the end of the first trimester, the abortion decision and its effectuation must be left to the medical judgment of the pregnant woman's attending physician, the opinion said. Between the end of the first trimester and viability, the state, in promoting its interest in the health of the mother, may regulate the abortion procedure in ways reasonably related to maternal health. Subsequent to viability, the state, in promoting its interest in the potentiality of human life, may regulate and prescribe abortion except where it is necessary for the preservation of the life or health of the mother. Beginning in 1976, federal law, the Hyde Amendment, first passed, severely limiting the use of federal funds to reimburse the cost of abortions under the Medicaid program, which provides health care for low-income persons. Since 1976, the Hyde Amendment has been continuously attached to federal appropriation bills and has been upheld by the Supreme Court as constitutional because, according to the court, there's no constitutional entitlement to an abortion. This law severely restricts the access to abortions for women who are materially poor. And the second Supreme Court case I wanted to just mention to set the table is the 1992 case, Planned Parenthood of Southeastern Pennsylvania versus Casey, where the Supreme Court upheld the central holding of Roe versus Wade, which the court defined as, quote, the right of the woman to choose to have an abortion before viability and to obtain it without undue interference from the state. The court reasoned that the state's power to restrict abortions is limited, both temporally and by the mode of restriction. Looking at the non-viability period, states may not restrict abortion except if the regulations do not establish an undue burden on the woman's ability to have an abortion. After viability, any regulations burdening abortion rights, Casey said, must create exceptions to preserve women's health. As professors Michelle Goodwin and Megan Thompson argue, the court's decision in Casey weakened the abortion right by, quote, downwardly shifting the legal standard, unquote, guarding its protection from strict scrutiny to the less robust and porous undue burden standard. So with that introduction and setting of the table, let's get started. I'm first going to turn to you, Ms. Mahan. Can you explain the reality on the ground for abortion providers and pregnancy-capable people before Texas SB 8 and Mississippi's Gestational Age Act were enacted?
Absolutely. And I wanted to say thank you so much for having me today. I'm really excited to be here. I also wanted to start by saying as a disclaimer that although I'm a lawyer, that everything reviewed here is not legal advice, and all of the observations and opinions expressed are my own and not that of Brad or Rap. And so I'm going to start by reviewing basically reality on the ground prior to SB 8 in Texas. And so abortion providers in Texas have struggled to reopen clinics that closed because of restrictive state laws, even prior to SB 8. So 23 of Texas's 42 surgical abortion clinics closed after the state passed a law in 2013 requiring clinic physicians to have admitting privileges at a hospital within 30 miles. And as you may know, SCOTUS overturned that law in 2016 in the Whole Woman's Health versus Hellerstedt case. But today there are still only 19 clinics offering surgical abortion care in Texas, a state that's home to at least 29 million residents. And so most clinics are clustered in the major cities of Dallas, Houston, and Austin, while patients who live in smaller cities and towns that once had clinics now have to travel very long distances to get an abortion. And so to give you a sense of the landscape in Texas prior to SB 8, and these laws that I'm going to cover, these trap laws are also still in effect, just to give you a sense of some of the restrictions that providers and patients have to navigate. And so in Texas, there's a requirement for state-directed mandatory counseling that is biased. It includes information designed to discourage patients from having an abortion. And then there's also a 24-hour waiting period prior to the procedure. The counseling, unfortunately, must be provided in person for patients within 100 miles of the provider, and has to take place before the waiting period begins, and therefore requires 2 trips to the facility. The use of telemedicine to administer medication abortion is prohibited, which is really unfortunate because we've seen the rise of telemedicine used to provide medication abortion to pregnant folks during the COVID-19 pandemic. And unfortunately, that's not a reality in the state of Texas. Like many states, the parents of a minor must consent and be notified before an abortion is provided, unless they are able to secure judicial bypass. And then a patient must also undergo a 24-hour, must undergo an ultrasound at least 24 hours prior to obtaining abortion care. And unfortunately, the provider must also show and describe the image to the patient, which we know can be very triggering. And then for an abortion prior to SB8 to be performed at 22 weeks after the patient's last menstrual period, that can only occur in cases of life endangerment, severely compromised physical health, or lethal fetal anomaly. And unfortunately, that law is based on the assertion, which we know is inconsistent with scientific evidence and has been widely rejected by the medical community, that a fetus can feel pain at that point in pregnancy. And so now I'll shift gears a bit and talk about the reality on the ground in Mississippi.
Before you do, can I just get a clarification? You talked about TRAP laws. What does TRAP stand for?
It stands for the Targeted Regulation of Abortion Providers. And I'll talk about this a bit more when I review RAP's work. But we've seen and we understand that abortion providers are really regulated in ways that other healthcare providers are not. So thank you for that question. And then in discussing Mississippi, you might see that when I review the TRAP laws there's a lot of overlap because we're discussing two of the most heavily regulated states in the country. And so to go over the landscape a bit, in 1992, Mississippi had 8 abortion clinics. By 2014, it had 2. And today it has 1. And that's Jackson Women's Health Organization, which is the clinic at the center of the case that will be heard before the Supreme Court in December of this year. However, the abortion rate in Mississippi is almost 4 times lower than the national rate, despite the state's unintended and teen pregnancy rates being substantially higher than the national average. Mm-hmm. And Mississippi has some of the most stringent abortion laws in the country. I should have mentioned this earlier, but both Texas and Mississippi have trigger bans in place. And what that means is that there is a state law that's been enacted, and it's designed so that abortion is banned within that state immediately should the Supreme Court overturn Roe v. Wade. Right. Again, patients must receive that state-directed bias counseling. There is a 24-hour waiting period. Unfortunately, the counseling must be provided in person and has to take place prior to that waiting period. Again, there are 2 trips required to the facility, which we know is extremely burdensome for folks living in rural areas, individuals that need to take time off of work or obtain childcare. And unlike many other states, in Mississippi, for minors, both parents of the minor must consent before an abortion is provided, unless they are unable to obtain judicial bypass. Patients have to undergo an ultrasound before obtaining care, and the provider must offer the patient the opportunity to see that image. And then an abortion that is performed 20 weeks after the patient's last menstrual period can only occur in cases of life endangerment, severely compromised health, or lethal fetal anomaly. And then the state has several of what we refer to as reason bans, which prohibits abortions performed for the sole purposes of race or sex selection or in response to genetic anomaly. The state requires abortion clinics to meet unnecessary and burdensome standards. For instance, while several states have laws limiting the provisions of abortion care to physicians, thereby preventing other qualified licensed clinicians from offering the service, such as nurse practitioners, the state of Mississippi takes it one step further and requires abortion providers to also be board certified OBGYNs. So hopefully that gives you a sense of the obstacles that patients and providers were required to navigate in Texas and Mississippi prior to SB8 and the law at issue in the Jackson Women's Health SCOTUS case.
Wow, that's super helpful, Jen. And that's going to then lead me to ask you, Professor Morrison, we have these 2 new laws on the books. Can you tell us what they are, how they fit or conflict with the Roe, Casey, and other precedent that we have from the Supreme Court? Because we already had a lot of burdens in place. Tell us what's going on now with these laws.
Sure. Can you see my screen? Great. So let's start out with Texas. It is an absolute mess. I've never seen any law that's like it. And so I wanted to have a slide so I could actually unpack some of these provisions. Starting off, unlike other abortion bans, Texas does not set an explicit gestational period. As we said, it's a matter of the cardiac activity that the doctor hears when the doctor is required to do a test before performing the abortion to try to detect that cardiac activity. It's generally been referred to as a 6-week ban, but as been said in the introduction, the actual timing of that, when we know what biology is of menstrual periods, could push it back as soon as 4 weeks after conception. But 6 weeks is generally the accepted time when cardiac activity is detected. Another really unique aspect of this law is the aid and abet provision. And what this law seeks to do is to cast a wide net over those who can be brought into court and to further stigmatize and isolate people who are actually in need of support and care. The other thing that is wholly unique about this, and it's been called kind of the vigilante law or bounty hunter law, is that the law has turned over its enforcement to private citizens. I and other commentators have likened this to fugitive slave laws. Individuals are deputized by the state to return human property to its rightful owner, with the incentive of receiving a bounty for doing so. An article in the Daily Beast by Callie Holloway argues that given how closely Black people have been surveilled for things like sleeping on lounge chairs, having picnics, walking, breathing, looking at property, meeting in Starbucks, we can absolutely expect that this law will disproportionately target the Black community. You will have a lot of scrutiny towards Black women of reproductive age who can be kind of swept up in this for any actions that they take. Another really completely unique provision is taking the state out of enforcement. So it's one thing to say that you can have private individuals enforce it, but they did an administrative trick of taking the state out of enforcement in order specifically to make this law pretty much unchallengeable in a way. So the question is, who can actually be sued? You have these hypothetical individuals out there after the law goes into effect, but before they take any action, there's actually no one who can be sued. So that's been a lot of kind of the conflict that's been going on in the courts that has allowed this law to take effect. I should also say that one of the people who cannot be the claimant, and I guess this is kind of the example of the state trying to be gentle, is that the person who actually caused the pregnancy by means of rape or incest, that person cannot be a claimant. So there is Texas's nod to recognizing that there are women who are actually subjected to abuse. So going to the next provision. So this is another really big deal. So everyone's been following this kind of ping-ponging back and forth. The law's in effect, the law stayed, the law's in effect, the law's stayed. For practical purposes, this just doesn't matter. There is a provision in the law that says what is not a defense is reliance on a court decision saying that the law has been overturned at the time of the doctor's conduct. So this means there's a stay on Monday, an abortion on Tuesday, and another court reverses that stay on Wednesday. This provision says that a doctor can be sued for that Tuesday abortion, despite the fact that a court had stayed the functioning of the law that Monday. So the explicit purpose was to actually keep any people from sneaking in and having abortions during any time when this law was technically legal. The law was technically suspended. I should also note the law prohibits the award of costs or attorney's fees. So this means you could have someone, an abortion vigilante, that can go out again and again and again and file what are admittedly frivolous lawsuits, right? After you know it doesn't work for the first time, then you could just keep doing it. But because the law explicitly states that a court may not award costs or attorney's fees, there's no penalty to that. So there's no disadvantage to simply harassing individuals or doctors by filing these lawsuits again and again. So some additional provisions, and this was really the way they crafted this law. I have to admit it's crafty. It's crafty, and there are all kinds of procedural shenanigans that are in the law. For law students who are taking something like statutory interpretation, I encourage you to actually go read the statute. Like, this is what professors tell you all the time. One of the things that it did was respond to all of the Supreme Court precedent that was favorable to abortion access. So one big issue that has been, I'd say it's kind of been a given since Roe v. Wade, is that doctors have standing to challenge these types of lawsuits. There was a challenge to doctors standing in June Medical. So this law contains language that actually tries to remove third-party standing for doctors, buried way, way deep in there, because there's so many awful things in it that you're paying attention to the big awful things. There's some small awful things that also need to be highlighted. It attempts to limit challenges to as-applied challenges only, so no facial challenges. So what the statute says is that if there is a particular limited category of individuals for whom this law would be unconstitutional, that, okay, fine, the law is unconstitutional for them, but for everybody else, this law still stands. And then, I think most gallingly, it tries to define what is and is not an undue burden, as though a state legislature can do that. So it is very kind of aggressive in trying to push back on what we know was already a reduced standard of scrutiny from Roe v. Wade. A few more things that I picked up in some of the additional language is that it changed the language on the form that exempts individuals who are having an abortion for reason of fetal anomaly. It changed the language that on the form that exempts them from looking at sonogram pictures. And it changed the wording from fetus to unborn child. So that those who are going in to actually have an abortion or a permissible abortion still have to look at that form and read unborn child as opposed to fetus. It also added language to cover medical abortions in addition to surgical abortions by adding the word induce. The Mississippi law is far more clear-cut, looks very familiar to those who are used to dealing with abortion restrictions. It has a clear 15-week ban. It's a much more traditional ban. What I find galling about this is that as we started seeing with a lot of the abortion cases after Carhart, was a lot of language about protecting women, about how these laws are drafted to protect women. The preamble of this law states that the goal is to protect maternal health and the additional risk of second trimester abortions. But as Ms. Manahan went through, all of those restrictions, all of those trap laws, all of those waiting periods, all of that parental consent are actually the things that delay abortion. So if they actually had an interest in reducing any potential additional harm from later abortions, they would actually remove the barriers to earlier abortions. But of course, that is not what is happening at all. Medical emergency is very narrowly defined in the Mississippi law. It's an abortion that is performed either to preserve the person's life or if continuing the pregnancy will cause, quote unquote, serious risk of substantial and irreversible impairment of a major bodily function. And that is a very narrow reading of what a medical emergency is. So this is a criminal law. The last one was a civil law, I should point out. This is a criminal law. So of course it requires the act of the state to be involved in its enforcement. And additional penalties are a $500 fine and a revocation of a physician's medical license. I think that's it for these two laws.
Well, thank you so much, Jill. That is really informative. And I love how you picked out things that, I have read that law and I have read a lot of commentary, but you picked out things I had never thought of before. So thank you for that, sharing your interpretation of the statute. I'm going to turn to you, Professor Gilman. You do a lot of work in the area of privacy and surveillance. What are your surveillance concerns, if any, related to Texas SB 8? Jill Morrison just talked about the fact that we've got these bounty hunters and vigilantes in this law that we don't see in, say, the Mississippi law. Can you tell us a little bit how you look at it in terms of the surveillance concerns?
Sure. So, as Professor Morrison described, the law provides this $10,000 bounty and attorney's fees for private citizens who turn in people who provide or aid women in obtaining abortions. This is shifting the law enforcement function from the state to private citizens. And it allows these vigilantes to sue complete strangers, including doctors, nurses, the receptionist at the abortion clinic, other clinic workers, insurance companies, family members, friends, even the Uber driver who drives a woman to an abortion clinic. And these vigilantes, they don't even have to live in Texas. They can claim their bounty from anywhere. This is not how a healthy democracy that respects the freedom of its citizens functions. This is the sort of like private spy network one sees in totalitarian dictatorships, right? Like the USSR or today in North Korea, where neighbors are encouraged to spy on and turn in their neighbors. This is not in line with American values, and it really threatens to weaken family, friendship, and other community bonds. And this is because a pregnant woman seeking advice in making this major life decision, potentially impacting the rest of her life, may be too terrified to seek support from her doctors or her social networks because she fears exposing all those people and others to litigation and to being the target of this bounty. And already abortion providers in Texas are reporting that calls to their hotlines have fallen precipitously because people don't know if it is safe or not to seek the support that they need.
Yeah, that's chilling. And that is the intent. So thank you so much for that. I want to go back to you, Jill. You're an expert in reproductive justice, and I'm wondering, what is the reproductive justice framework? I talked about that as part of your background. What is that exactly, and how might the Supreme Court decisions this term regarding the Mississippi case, and I assume they'll be hearing the Texas case as well, impact that reproductive justice framework? And what can or should be done to strengthen reproductive justice at this time?
So reproductive justice is a theory that was created by Black women activists in 1990.
Jill, your sound is coming in and out. Maybe go closer to your mic.
Yep,
Thanks.
Sure.
This is important. We want to hear it.
So the reproductive justice framework was a response specifically to a reproductive rights framing that didn't really include holistically all of the concerns of all women of color, low-income women, young women, but especially the Black women that were in that room. So in part, it's because the Roe v. Wade is based on a right to privacy. And the right to privacy is essentially those bumper stickers that you say, U.S. out of my uterus. Well, there are going to be times when I actually need the U.S. to help me, actually help me effectuate some of my reproductive decisions. So this is kind of part and parcel of what reproductive oppression looks like. It is creating two classes of women within these states. The women that have the ability to get out, that have the means, that have the contacts, that have the knowledge, that have flexible work hours, that have childcare, and leaving the rest of those women behind. So it is just further re-entrenching reproductive oppression. There's a fantastic book on what happens when women do not get abortions that they wanted, called The Turnaway Study, by Deborah Foster Green. I highly recommend it. I hate to think that it's just going to become more and more relevant. But for those of us who care about these issues, I don't think there's a better source material of really understanding what happens.
Yeah. Thank you for that. And I think that dovetails with my next question, which is for you, Michelle. talking about what are the economic justice implications for SB 8. I think you mentioned when we were talking about this as it was happening, that there's some good data or information about the economic justice outfall from SB 8.
Sure. So abortion restrictions, they not only impact the health and the autonomy of women, but they have devastating economic consequences as well. It's important for women to be able to control the timing and the size of their families so that they have children when they are financially ready and when they are emotionally ready. Access to the full array of reproductive justice, as Professor Morrison was just describing, allows women to finish their education, to advance in the workplace, and to have children at a time that fits into their lives and that they can support. And this was recognized by the Supreme Court in the Casey decision that Professor Johnson mentioned earlier. The Supreme Court said, and I'm quoting, "The ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives." Unquote. So SB 8 is part of a much larger concerted effort by conservatives to control women's bodies. For instance, conservative attacks on birth control are escalating. And yet access to the pill alone is responsible for 1/3 of women's wage gains since the 1960s. Moreover, we know that children who are born to mothers with access to family planning services benefit from a 20 to 30% increase in their lifetime incomes and higher completion rates. Consider that 1 in 5 children in Texas lives in poverty. SB 8 will worsen that. And as already been mentioned, abortion restrictions hit low-income women particularly hard. Half of all women seeking abortions live below the poverty line. These women will struggle to travel out of the state of Texas to secure abortions because travel costs money, childcare costs money, missing work costs a lot of money. And this is all piled on top of the cost of the abortion procedure itself, which is not covered by Medicaid, the health insurance program for people experiencing poverty, as Professor Johnson mentioned at the outset. One study showed that because SB 8 is going to lead to the shuttering of numerous abortion clinics in Texas, it will increase the average one-way driving distance 20-fold for women seeking abortions, from about 12 miles one way to 248 miles. And so we know that this has both implications for reproductive justice and for economic justice.
Yeah, and really, I mean, I can imagine we can't talk about reproductive justice without talking about economic justice. It's an intersectional framework that is looking at the impact of race and economic and other social characteristics that result in, as you were saying, Professor Morrison, this idea of where do we want the state not to be involved and when do we want the state to involve us? And the right to privacy, of course, has this legacy of being used and only being available to families with means. And of course, we know the famous case of Wyman versus James, where the Supreme Court did permit the state to just walk right over that right to privacy because Ms. James, right? Or Ms. Wyman, Ms. James was receiving Medicare at the time, or welfare at the time, welfare benefits. And so we know that there's this big divide in our society about who actually has a benefit to be had by the state not being involved and who is burdened. And I know also in terms of reproductive justice, Professor Morrison, I've read a lot since SB 8 came into effect about the reality in Texas that, you know, a lot of women of color, if we think about immigrant women of color, really had no access to abortions on the ground at all. And so this idea that all of a sudden we were facing a crisis because SB 8 came into effect was sort of like a rallying cry to, wait, you don't understand what had been going on for the reality of many women's lives as Jen had been talking about, for just the lack of access in general, because of the Hyde Amendment, because of where they live and the remote access, and for these other issues that you and Michelle were talking about. So thank you for bringing that into the conversation. It's a super important thing that we can't lose sight of, and can't just focus on SB 8. We have to understand the full context and the nuance of how it affects where we are today. So I guess with that, I'm going to turn to you, Jen, and I guess I'm going to sort of move us away from the law and just, we want to learn more about the work that you're doing. We're so proud of you as an alum of our school, starting the If, When, How chapter, which we are very proud has co-sponsored this event with us in the Center on Applied Feminism. And you really started that If, When, How chapter here at UB. So we're so proud of that. And you've been really doing this work since you were in law school, since you graduated. What are you doing now in your current work on behalf of abortion providers? And tell us a little bit more about your organization.
Sure. Yeah. And I'm so thrilled to hear that the If, When, How chapter at UB is doing great. One of my most fondest accomplishments during my time at UB. And also, I wouldn't be where I am in my career now. I'm confident of that without the help that I received from Professor Johnson, getting to work as her research assistant, and all of your help with the If, When, How chapter. So thank you for that. So I can give everyone an overview of what RAP is. So I'm completing a year-long fellowship with regulatory assistance for abortion providers. And so RAP provides pro bono legal compliance advice to abortion providers across the country. And so while states have some level of regulation and oversight over healthcare providers, legal compliance is especially important for abortion providers. Over-regulation of abortion providers is an anti-choice strategy that is used to limit access. It takes time away from abortion care and adds stress to not only the providers, but also their staff. And so in some places, the burdens of compliance has actually caused providers to suspend or limit their services or decide against opening new centers or expanding, and has also caused clinics to close. Compliance is also especially important for providers because, unfortunately, they are often scrutinized more closely than other healthcare providers and often face hostile inspectors. And so RAP assists providers who are working on complying with new or existing restrictions, expanding or modifying their abortion services, like expanding the gestational age limit that they're able to provide care to, or adding telehealth services, preparing for or responding to an inspection, as well as providers who are considering making changes based on upcoming court decisions that may reduce abortion access. And so we work with both independent, so non-Planned Parenthood, and Planned Parenthood providers. We do not represent clients in litigation or do any type of advocacy work. We also do not answer financial or billing questions. And we're currently a team of 5 attorneys. And in May, it was really exciting. RAP published a guide to help providers understand the legal questions that they should consider when launching or expanding telehealth services for medication abortion, which was very timely with the COVID-19 pandemic, as we saw a spike in the use of telemedicine for medication abortion. And we are a team within an organization called Resources for Abortion Delivery, or RAD, which provides other type of assistance to independent providers, like funding and technical as well as operational support.
Well, what a great organization. Thank you so much for letting us know about it. Is that guide to the legal questions and answers regarding telehealth abortion, is that publicly available or just for your providers?
That's kind of a difficult question to ask in that we try to be very careful with the way in which we share resources. So say that we were providing a webinar strictly to medical providers, that might be a forum in which we would broadly share that resource. If folks are interested in reviewing that, I could go back to the organization to see if the attendees here could gain access to it, as I think it is a wonderful resource, but we do try to take those additional precautions just because of the sensitive work that our clients are engaging in.
Yeah, that makes sense. But it would be worth knowing if it is available. I think there are many of us who would be interested in it. Yeah. We do have a question in the Q&A, but I'm going to get to it after I ask Michelle Gilman a question, because I think it might lead nicely into the question itself. So Professor Gilman, going with what Ms. Mahan was talking about in terms of these trap laws that are really just an anti-choice strategy, right? You so overly regulate the abortion providers that it becomes futile, frustrating, very difficult to actually operate and provide services to those who need them. And the result then is to sort of achieve a social outcome, which is not to have abortion available at all for people who are pregnant. I'm wondering, you talked earlier about the surveillance that was embedded in SB 8, and Professor Morrison talked about that as well. But for you, do you see that this law is fitting into a broader pattern of surveilling women's bodies? And could you talk about that?
Yeah, you bet that I do. SB 8 is a new twist on longstanding dynamics. So women seeking abortions regularly face protesters outside of the clinics with their bullhorns and their signs where they harangue patients. They sometimes take photos of patients. They've been known to take down license plates of patients. And so they're using surveillance as a way of instilling fear in women who are asserting their constitutional rights. And now protesters have a new tool in their toolbox. They're using GPS capacity on cell phones to track women seeking abortions, and they're using geofencing technology to identify these women and then to subsequently bombard them with ads seeking to discourage them from going through with the abortion and to put their children up for adoption. Okay, so this sort of private conduct is layered on top of the state's social control of women and abortion providers that Ms. Mahan has covered so thoroughly. In addition to trap laws and laws of that sort, we should also mention that there are laws popping up all over the country that criminalize pregnancy losses, such as miscarriages and stillbirths. Just last week, a 20-year-old Oklahoma woman was convicted of manslaughter and sentenced to 4 years in prison after she had a miscarriage at 17 weeks. And this was because it was found that her fetus tested positive for certain drugs. However, there was no evidence at the one-day trial that drug use was in any way connected to the miscarriage, and it shouldn't matter because jail is not the answer for treating people with addiction issues. Treatment and support of pregnant women struggling with addiction is the answer. And unfortunately, this type of case is not unique, and these criminal prosecutions are almost exclusively targeted at low-income Brown and Black women. And surveillance, of course, of women is not just about pregnancy. Surveillance extends to all aspects of women's lives. Even just walking down the street, women and girls are constantly subjected to catcalling or street harassment. This is a form of surveillance in which men signal their entitlement over women's bodies and intend to instill fear in women and emphasize their powerlessness. Women are disproportionately stalked and harassed in the real world and online. Domestic violence often involves surveillance and control of a victim by her abuser. Low-income women who receive public benefits must agree to put their lives under the microscope of government agencies as a condition of receiving benefits such as food stamps or Medicaid. And the list goes on and on. There really are very few areas of women's lives that are not lived under some form of public or private surveillance.
Yeah, thank you for that. I mean, my recent work has been in the area of menstruation and law, and you too have written on this, that there is great surveillance of people who menstruate and trying to control their menstruation. And two great colleagues in Australia have documented the involuntary sterilization of people who menstruate. So a very grim reminder of the surveillance and control of bodies, of women's bodies. I just want to say to Chris Stutz, who's doing an amazing job in the chat of giving all of our audience some really wonderful links. Maybe you could put in the chat a shout out to the National Advocates for Pregnant Women. This is an organization founded and run by Lynn Paltrow, and they represent women who are facing criminal sanctions because their children may have been tested positive with drugs. And with that shout out, I just want to say she is a former fellow of the Women's Law and Public Policy Fellowship Program. I am too. And Jill, who directs this program, is doing an amazing job in making sure that we have a lot of fierce advocates working on these issues for many years to come. So thank you for that work. I'm going to turn to you, Ms. Mahan, and ask you, we've been reading lately about the United States versus Texas case. So this is the challenge by the United States. After the Supreme Court said on the shadow docket, we are not going to touch SB 8 at this point, we don't think procedurally we can. The United States filed a federal district court complaint against Texas that was regarding SB 8. And it's been in the press a lot because it's taken a lot of twists and turns. And I'm hoping you can help us out here by explaining what that lawsuit is about. And then I promise I'm going to get to the Q&A because I forgot to get to these great questions in the Q&A, but I will get to them after Jen gives us a little insight into the US v. Texas case.
Sure. So I'll try not to take too long with this, but like you said, there are many different twists and turns. The lawsuit's moving very, very quickly. So I plan on providing a high-level overview of how it's unfolded. But I would also recommend listening to the Boom Lawyered podcast. It's hosted by Rewire News. They actually just released an episode today explaining how the case has unfolded, how it's been ping-ponging between the federal district and circuit courts and SCOTUS. So SB 8 went into effect September 1st after the Supreme Court refused to block the law as requested by abortion providers in Texas while it's being challenged in lower courts. So on September 9th, the DOJ sought an emergency injunction to block SB 8 long enough for a court to rule it unconstitutional. So the injunction was filed in federal court in Austin and sought both an immediate and permanent injunction against the law, which bars almost all abortions after the 6th week or, 4th week of pregnancy. So Massachusetts joined about 24 other states in filing a brief in support of the Department of Justice, and a hearing on the request for a temporary restraining order occurred on October 1st. And so Texas has argued broadly that the federal government doesn't have any interest in SB 8 and cannot bring a lawsuit, and that even if it did, the DOJ couldn't sue Texas as a way to stop the law since private individuals are the actors that are required to enforce the law. And so the Department of Justice argued that SB 8 is invalid under the Supremacy Clause, the 14th Amendment, and is preempted by federal law. And so citing testimony from doctors in nearby states, DOJ argued it has grounds to sue Texas based on the impact that SB 8 is having on interstate commerce. And so in the DOJ lawsuit, an abortion provider from a neighboring state testified to the unprecedented surge in demand for appointments from Texans, upwards of something like a 600% increase. And so in a court filing, Texas legal officials wrote that the record suggests that, if anything, the act is stimulating rather than obstructing interstate travel because pregnant people are forced to cross state lines to obtain an abortion. which I personally find to be horrific and egregious. I think that it's important to note that SB 8 was in effect from September 1st until October 6th, when a 113-page decision came from Judge Robert Pittman on the U.S. District Court for Western Texas. And so something that I like to think of as sort of like a silver lining is that advocates were really thrilled to see the use of gender inclusive language in the opinion, and a footnote stating that the court recognizes that not all pregnant people identify as women. And so Pittman was able to temporarily block enforcement of SB 8, restoring abortion access to countless Texans across the state. I was going to say I'm happy to say that abortion did resume at that time, but as Professor Morrison highlighted, the law carves out any sort of safe harbor. However, 2 days later, SB 8 went back into effect after the Fifth Circuit Court of Appeals granted a request by the state of Texas and temporarily paused Judge Pittman's injunction. And so the order came from a 3-judge panel from the Court of Appeals for the Fifth Circuit, granting what's known as an administrative stay, which is not permanent. And so the DOJ appealed the Fifth Circuit Court of Appeals decision to reinstate enforcement of the law. And so the latest update is that the Fifth Circuit gave Texas until today at noon to file a reply brief. So we could see an update as early as tomorrow. And then the Fifth Circuit will issue a ruling about the state's request for a longer term stay on the district court or Judge Pittman's injunction. And so that was as brief as I felt I could be, providing an overview of the DOJ lawsuit.
That was a great job. So I'm going to turn to the Q&As. Thank you for that, Jen. And Jill, I'm going to come to you. We have a lot of questions about the Texas law. So the first one is, are there any provisions in SB 8 limiting the number of claims that may be lodged against someone who assists a woman in accessing health services? For example, could multiple, according to this questioner, pro-life zealots target a health practitioner, Uber driver, close friend by lodging multiple claims against them for the same event?
Yes. Quick answer. $10,000 a pop. Yes.
Okay. Can you expand on, again, Jill, to you, can you expand? Well, 10,000 is the minimum, right? We don't know what the ceiling is, right? Okay. Can you expand on who can be held responsible for aiding and abetting under the Texas law? Specifically, can residents of other states be sued for providing financial support for a Texas resident to seek an abortion?
So I take a personal interest in this question because I am a donor to Texas abortion funds.
You're fading in and out, and I want to hear this. This is important.
I'm a donor to Texas abortion funds, so I take a very personal interest in this question as to whether or not I could be sued. Yeah. What is the general line is, could they be sued? Absolutely, because anyone can be sued. The question would be, if you were providing financial assistance, did you have reason to know that that person was seeking a post-gestational heartbeat abortion in Texas? So tons of money is pouring into Texas abortion funds, and those abortion funds are not helping women get abortions in Texas. They are helping them go out of state. So for that reason, they are not violating the law. But in terms of asking the question, who can be sued? The answer is everybody.
Okay. Helpful. Jen, I'm going to come to you. Do you know if Texas clinics have started resuming care since the injunction earlier this month, given that they are potentially still subject to liability for care during this period?
I believe so, but I'm more familiar with the fact that providers were able to resume care when that injunction was handed down through the DOJ lawsuit, but that was only for a period of about 2 days. And I think it's more accurate what Professor Morrison was touching on about how there are funds that are helping folks get out of the state. And I also understand that providers within the state are helping their patients navigate that process of getting into clinics outside of Texas.
Thank you. I'm going to open this up for everyone. Oh, Jill Morrison's going to answer this live. Okay, awesome. Is Texas considering legislation to increase support for and access to prenatal care, child health care, early education in response to SB 8, or is Texas pro-life but not pro-child?
Another quick answer: they're pro-birth, and they're not pro-healthy birth, because if they were pro-healthy birth, then they would have all that Medicaid expansion and all of the rest of the good things. This is part and parcel of reproductive oppression. A lot of the things that Ms. Mahan was talking about with trap laws, a lot of the justification is to quote unquote make abortion safer. As it stands, abortion is multifold times safer than childbirth, especially for Black women. What you see in terms of maternal mortality in this country is absolutely atrocious. So the answer is just obviously no, but I appreciate you pointing out the hypocrisy of claiming that you are quote unquote pro-life while denying all of the rest of the lifespan.
Margaret, I can follow up on that briefly, because USA Today reported that according to the annual Annie E. Casey Foundation's 2021 Kids Count Data book report, Texas is ranked 46 out of 50 states for overall child well-being. And I quote here, these statistics track the realities of children who already live in the state, those in poverty, those suffering from food insecurity, those with no access to early childhood education, and those without health insurance, unquote. So Texas may be pro-life, but they do not have policies in place that are pro-child. And, as I said earlier, 1 in 5 children in Texas is poor. So.
Yeah, thank you both for that. We have a question from Professor Shanta Trivedi. I'll just give a shout out to her. She's one of our new faculty members. We're so excited she's here. And she was an LLM student or a Women's Law and Public Policy Fellow with Professor Morrison last year. So nice connections all around. Professor Trivedi asks, what can law students and others do to support pregnant people seeking abortions in Texas and other states where access to abortion is limited?
I think one of the most, the answer that you hear everywhere is, donate to your local abortion fund, the local funds in the state of Texas, if you're able to. Jane's Due Process is a wonderful organization that helps young folks access care. If you're not able to make a monetary contribution, they also accept volunteers for their hotline, and they're able to provide training. And I think also if you're living in the state of Maryland and you want to work with a local organization, NARAL Pro-Choice Maryland has worked in partnership to create the Maryland Abortion Access Alliance. And so you're able to assist folks who are traveling out of state with things like rides to a clinic or providing them with a place to stay while they're accessing care.
I have to take this question because at the beginning of this session, I was just shocked to see a very dear friend of my mother who passed away many years ago now, but also a very prominent psychologist in the area of domestic violence. Dr. Lenore Walker is here. And she asks, are any of the groups mentioned in contact with the American Psychological Association in order to assist with the psychological research available? Dr. Lenore Walker is a member of the APA Council of Representatives, and we have a group who are working on this area. Does anyone know? I don't know, but I really appreciate this, Dr. Walker, because this is an area where collaboration has to happen, and we need to share resources. So many times lawyers are in a lane, but we need the social science, the psychological data. So I appreciate you raising this, and hopefully people who are attending this webinar will also hear this and reach out to you for assistance. I will keep this in mind for our work as well. So thank you so much. We have 1 minute left, and I see there was a question about, you mentioned advocacy for abortion providers. What are some examples of advocacy groups for those seeking abortions in Texas? Does anyone know?
The abortion funds actually do that type of advocacy. They provide comprehensive support. It is not solely focused on the determination. You want an abortion.
You're fading in and out, Jill. Sorry.
Right. You want an abortion, so let's get you an abortion. It's actually some counseling and involvement there. There are also national organizations, including ones whose name is escaping me right now. That is non-directive abortion counseling. Exhale, yes. So that, yes, those resources are definitely out there.
Awesome. Thank you. Well, we are at time. This was an unbelievable panel. I thank you all for your willingness to come and share your knowledge with our community. Thank you so much, Jen. It's so wonderful to have you back at the law school, even though it's virtual. And Jill, it's so great to have you here. And thank you for all the work you have done and continue to do, both of you. And of course, Michelle, my comrade in arms at the Center on Applied Feminism. Thank you so much. I'm going to leave with a comment that we had in the Q&A. The anonymous attendee says it would be better to characterize Texas as pro-suffering than pro-life. So with that, we're going to call it a wrap. Thank you so much for being here, and we look forward to seeing you at a future webinar at the University of Baltimore School of Law. Bye-bye.